Hello everyone, hope you're doing well. So today we have this article in front of us. This article was published in the Indian Express. I'll refer to the date as well in the description. Now, why this article is important for us is because this article is about the recent happenings that are happening in Kerala. That is, of course, tussle between the governor and the chief minister. Now there have been future past instances of this happening as well in Delhi. If you remember, in Delhi, CM having a tussle with the lieutenant governor. Now UPSC has been known to ask questions related to topics which include points of contention, because they have been known, because if you get selected in the service, there might be points where you might also be involved in things like this. So all these issues require a constitutional uh, understanding of the constitution, understanding of the roles of different powers that are attached to it, and having a better grip of the solution what can be expected. Now hence this becomes very important for us to understand this from the mains and the prelims perspective. If you understand this, there has already been a question in the prelims, I believe, and the mains as well, from topics of the governor and chief minister and the point of contention between the two. So let's understand this article and what can we understand. We'll do a detailed and in-depth analysis. So stay tuned till the end. All right. So tussle in Kerala, can Governor Khan dismiss a state minister? Now the current governor is Arif Mohammed Khan, and there was he threatened to sack a minister who lowered the dignity of his office. Now the chief minister has uh, accused the governor of dictatorial powers, and there has been no occasion so far the governor nor unilaterally removing a minister from the government. And can the governor do that or not is to be understood from this video. First we have to understand what role does the governor play in the parliamentary system, right? The first thing is the articles related to the governor. This becomes important from the perspective of polity as well. Articles 153. All right, I'll just articles 153 to 161 deals with the topic of governor, right? And the position of the governor is similar to that of the position of president at the union or the center. And the governor is the head of the state's executive power. So the governor would be the one who appoints the executives for the state, that is the IAS for the state, the IPS for the state, because these are all the executive powers of the state, right? And barring some matters, what are acts on the advice and aid of the council of ministers. So ultimately the governor lies on the council of ministers, which is responsible in accordance with the parliamentary system to the state legislature. So governor is the head of the executive who works on the aid and advice of the legislature, that is the council of ministers for the state legislature. The governor is appointed by the president on the advice of the central government and therefore acts as a vital link. So hence you can see the link here. So we have the central government here and we have the governor here. This is the governor, and we have the state legislative here. So the central legislative and the state legislative are joined by this link, that is the governor. Acts as a vital link between the union and the state governments. The role of governor has been a contentious issue in the center-state relations for a decade. The governor enjoys certain powers such as giving or withholding assent to a bill passed by the state legislature, or determining the time needed for a party to prove its majority. So there are two things. The governor can provide his yes or a no for a bill, yes or no, in complex terms or in answer writing terms is called assent of the governor for a bill passed by the state legislature. So after the state legislature forms a bill, they send it to the governor, who then signs it, and then the bill becomes a state law. Understand this. All the things that are present in the state list, not in the central list, the state list, the state can make laws for them. To make a law, the state will first pass a bill in the state legislature, which has to be passed. Then the bill would be sent to the governor for his assent. The governor has this power to withhold his assent. The second power that is present with the governor is to determine the time, right? Determine the time needed to form or to prove majority. As you must have seen in the cases of Maharashtra as well, the governor, if the governor thinks that the government or the people who are competing in the government for the position of the government, the CM or the Council of Ministers, they need more time to prove their majority, the governor will directly make sure that this happens. There are few cases that you can read. I believe this was S.N. Bonmai case. This is a very famous case that happened in Karnataka. This happened in Karnataka, where the governor, on the first hint that the government is collapsing, called up the next person to take up the charge, and this happened. All of this happened in the stroke at the midnight. In the middle of the night, the governor called up the next person to become the chief minister, and he administered him the oath as well. So these are some case studies that you can also refer to better understand the issue. All right. So, or which party must be called in to do so? Generally in a hung assembly. So when there is a hung assembly, when there is a no clear-cut majority, the governor might give time for a party to prove its majority, which have been weaponized by successive central governments against political opposition. Article 164, Clause 1 says that, Part 1 says that ministers shall hold office during the pleasure of the governor. So now, does this mean that a governor, if does not feel pleasured by the minister, can remove him or her? Let's understand this. So the article says he can appoint a minister only on the recommendation of the chief minister. Right? So the chief minister, let's say he's the chief minister, he recommends that, sir, I want this person to become the council of minister or to become the minister of state for this, right? The governor has no power to pick anyone he chooses to make a minister. So the governor does not chooses the minister. He just appoints the minister on the advice of CM. Right? So in a what should we say, in an ideal democracy, the governor is just seen as a power that appoints the candidates or appoints the ministers on the advice. He works solely on the advice of Council of Ministers of the chief minister. In Shamsher Singh and versus State of Punjab 1974 case, this is a case one that we are discussing right now, that is present in the article. The Supreme Court said, we declare the law of this branch of our constitution to be that the president and the governor, custodians of all executive and other powers under various articles, shall exercise their formal constitutional powers only upon in accordance with the advice of ministers, save in a few well-known exceptional situations. Right? So the governor typically works on the advice of the Council of Ministers for the state legislature. These situations could arise if the PM or CM cease to command majority in the house, the government loses its majority but refuses to quit, and for the dissolution of the house where an appeal to the country is necessary. So when the assembly needs to be dissolved, right, Suppose the CM and his council of ministers and his government lose the majority, but they are refusing to quit, right? He can be made to quit when the governor dissolves the assembly. Technically, if you say, chief minister has the power of state legislature in his hands. If the governor decides to dissolve the assembly, the state legislative assembly, then the chief minister holds no power. So, in that sense, in a case where the chief minister is not able to prove his majority, the governor can dissolve the assembly, and then he can tell the next person or any person who wants to prove the majority to be the next CM, as you can say happened in the case of Maharashtra. But even in the third scenario, that is this scenario, the head of the state, the president or the governor, should avoid getting involved in politics and must be advised by his prime minister or chief minister, who will eventually take the responsibility for the step. So, again, in an ideal democracy, what happens? The governor takes the advice of the chief minister so as to what would be the next step, or take the responsibility of proving majority, or giving him time to prove the majority. This is what happens in an ideal democracy. But what we have seen over the past years, that the governor gets involved in the politics, um, calls in calls in to form the government whoever or whichever party he is nearer or dear to, and then there's a tussle between the state government, the opposition of course, and the governor. This is what we have seen happening in the cases of Maharashtra, Karnataka for that matter. So this is what we do not want, and in ideal democracy this should not happen. In Nabam Reba versus Deputy Speaker and others 2016 case, SC cited the observations of B.R. Ambedkar. What are the observations of B.R. Ambedkar? You can write exactly this line in the exam and you will fetch full marks for, I can say this line, of course. The governor under the constitution has no function which he can discharge by himself. No functions at all. No functions at all. While he has no functions, he has certain duties to perform, and think the house will do well to bear in mind the distinction. So B.R. Ambedkar says very clearly that governor, though he has no functions at all, he has certain duties to perform. So he works for the state. Arcari said that in a deed, a minister lowers the dignity of the governor of or his office. Raj Bhavan can ask the CM to inquire. If found that the minister was deferred or disrespectful to the governor, he or she can ask the CM to drop the minister. You can ask. There's a difference between ask and doing. Asking and doing. So, what does the pleasure of the governor mean? So, this we are going to study in detail. Right now. I'm going to explain everything. This is called the pleasure doctrine, right? Let's just read the article, complete it, and then we'll move on to the notes and the analysis. The governor can withdraw his pleasure only when the government loses majority but refuses to quit. And he withdraws the pleasure and dismisses it. Without the advice of the chief minister, a governor can neither appoint nor dismiss a minister. That is the constitutional position, and this is where the governor ends. That's it. The governor, to conclude this entire article, the governor cannot make a minister quit. He can just ask the CM to inquire the issue and make and to dismiss the position of the minister, but he cannot appoint or dismiss a minister. That is it. And this is the constitutional position. The governor can only dismiss a entire government when they cannot prove their majority in the state legislature, right? The working of the constitution appointed by Atal Bihari Vajpayee. So, National Commission review. Attempts have been made to address concerns over the alleged partisan rule. Partisan role means when you are taking a side or when you are biased into something. So Atal Bihari Vajpayee governor recommended governor of the state should be appointed by the president after the consultation with the chief minister of the state. So there are few things that happened to improve this position, and we're going to read this in the editorial analysis. Just a minute, I'm switching the screen right now. Right, perfect. If you can see on the screen right now, we have the complete analysis, and this is available on the web. I will provide the link in the description as well. Now, as I've told you, for prelims, these are the constitutional provisions related to the governor. For mains, we have to understand the friction points between the governor and state relations. What I asked you and what was present in the article was pleasure doctrine. Let's understand what is pleasure doctrine. The pleasure doctrine is a concept derived from English common law, right? Under which the head of the state, can dispense with the services of anyone in its employ at any time. At any time. In India, Article 310 of Constitution says that every person in the defense or civil service, that is, the people who are preparing and watching this video right now, of the union, holds office during the pleasure of the president. So if you guys imagine and know as well, when you get selected, there is a letter from the office of the president that the president has appointed you and has invited you to attend the introductory course at Labasna, Missouri. So this is what the letter includes. The letter starts like this, with the honorable mention of the president. The president wants you to attend. The president, at his pleasure, wants you to attend this course at Labasna. So this is what the letter is. So you hold the office during the pleasure of the president. Every member of the civil service in the states hold office during the pleasure of the governor. So at the state level, the governor is in charge of the executive, as you have just mentioned. However, Article 311 imposes restrictions on the removal of a civil servant. Civil servants being given a reasonable opportunity for a hearing on charges against them. Yes, this is possible. There is also a provision to dispense with inquiry if not practicable to hold one, and is not expedient to do so in the national security interest. We'll move on. Under Article 164, the chief minister appointed by the governor, and the ministers are appointed by the governor on the CM's advice. So this is the most important thing. The chief minister is appointed by the governor, and the CM advises the governor to appoint the council of ministers, right? Other ministers are appointed by the governor on the CM's advice. It adds that the minister hold office during the pleasure of the governor in a constitutional scheme in which they are appointed solely on the CM's advice. The pleasure referred to is also taken to mean the right of the CM to dismiss a minister and not that of a governor. Pleasure simply means that the CM has the duty and the responsibility and the right as well, constitutional right, to dismiss a minister, and the governor does not have this. We have just seen this in as the conclusion. In short, governor of an Indian state cannot remove a minister on his own. These were the Supreme Court cases that you can remember for the mains, and you can read them in the article that I will give you the link in the description as well. Let us understand the constitutional provisions related to the governor, right? Article 153, we have just mentioned Article 153 to 161 deals with the position of the governor. The articles from 153 to 161 deals with the governor. There shall be a governor for each state. One person can be appointed as the governor for 2 or more states. So we have Chandigarh, right? We have one more state. If you can Google it and write it in the comment section, what state has what 2 states have the same governor, right? A governor is appointed by the president and nominee, and is a nominee of the central government. It is stated that governor has dual role. He is the constitutional head of the state. He's the constitutional head of the state, bound by the advice of Council of Ministers. He functions as a vital link between union government and the state government. Articles 157 and 158 specify eligibility requirements for the post of governor. A governor must, citizen of India, be at least 35 years of age, not be a member of either houses of the parliament or houses of state legislature, and do not hold any office of profit. So what this means, what the two things mean, that the position of the governor should be non-political. He should not be affiliated to either house or any house of the state legislature. Second, he should not hold any office of profit. The governor has the power to grant pardons, reprieves, etc. This is given in Article 161, the last one. There is a council of ministers with the chief minister at the head to aid and advise the governor in the exercise of his functions, except some conditions for discretion. Article 163. So 163 tells us that the governor works on the aid and advice of the chief minister and the council of ministers. The governor appoints the chief minister and other ministers. Article 164. Governor assents, withholds assent, or reserves the bill for consideration of the president passed by the legislature assembly. Article 200. 200 tells us that the governor can withhold his assent or send the bill to the president. Governors may promulgate the ordinances under certain circumstances. Article 213. If you can remember, this is what happened in the case of Delhi, the lieutenant governor versus the CM of Delhi. There were certain ordinances that the governor did not find very attractive. Hence, he told the government, the chief minister, to look into them. What are the friction points of the governor-state relations? Governor is envisaged as a political head. This is the most important line in this current. A political head who must act on the advice of Council of Ministers. However, the governor enjoys certain discretionary powers granted under the constitution. Example, giving or withholding assent to a bill. Second, determining the time needed for a party to prove its majority. Which party must be called first to do so. So if party A and B, right? If party A has a clear-cut majority, everybody in the state knows that party A has won clearly. The governor still calls party B first, right? And tells them that I'm giving you the entire night. Entire night has been given to you to prove your majority. Understand, this becomes a case, very important case, because this is a clear cut, you can see, and we cannot say anything. We can, of course, the Supreme Court or the executive has to look into this, but it's a clear cut partisan role that can be seen. When the government A has clear cut majority, the governor is still giving time to the second government, the preferred government, for example, time to prove their majority. What happens in the entire night if government or the party B has increased the number of votes, or can have done some horse trading or anything like that in the political arena? They can and become and form the party at the state legislature, can become the winner party, and this is how the governor decides the future of the state legislature, generally after a hung verdict in an election. So yes, so this happens when there is a hung verdict, when there is a clear cut majority. That is why this is a very special and a hypothetical case that can be considered. So the votes need to be almost equal for the governor to do this, but this is again a hypothetical situation. There is no provisions laid down for a manner in which the governor and the state must engage publicly where there is a difference of opinion, right? So publicly they cannot do this. The governor has a 5-year tenure. He remains in the office only until the pleasure of the president. Governor remains at the pleasure of the president. In 2001, National Commission to Review Working of the Constitution held that the governor owes his appointment and his continuation to the union, the center. There is an apprehension that he is likely to act in accordance with the instructions received from the Union Council of Ministers. So, hence, this is the problem. This is the problem. The National Commission for Review said that the governor owes his appointment and his continuation to the union. When the union decides, the government will be re-elected. The governor will be re-elected. In the constitution, there is no guidelines for exercise of governor's power, including appointing a CM or dissolving an assembly. There is no limit set for how long a governor can withhold assent to a bill. This happened in the case of Delhi. A governor sends a report to the center which forms basis of the union cabinet's recommendation to president for invoking Article 356. So if the governor sends a report to the center that, sir, the constitution machinery of the state has failed, please put president's rule in the state, then the center can think about it and put president's rule in the state. This is Article 356, emergency, state emergency. What attempts have been made to address concerns? So these are all part of the solutions. Let's quickly and briefly go through them. Changes regarding selection of governors. Proposal by Sarkaria Commission. The Sarkaria Commission proposed the Vice President of India and the Speaker of Lok Sabha should be consulted by the Prime Minister in the selection of governor. Panchi Commission or Panchi Committee proposal proposed in its report that committee comprising of Prime Minister, Home Minister, Vice President, Speaker and concerned Chief Minister should choose the governor. So the governor should be chosen by Prime Minister, Chief Minister, Speaker, Vice President, President and the Home Minister. 1, 2, 3, 4, 5, 6. 6 people should choose the governor for a state. The Panchi Committee also recommended deleting the doctrine of pleasure, the one that we just read above from the Constitution, but backed the right of the governor to sanction the prosecution of ministers against the advice of the state government. So, Panchi Committee said that the governor can and should prosecute the ministers against the advice of the state government. So, they are taking away some powers but are giving some more powers. It also argued for a provision for impeachment of the governor by the state legislature. If this comes into play, there is going to be a huge ruckus that is going to be present. What is the solution and the way forward? The governors may differ with the contents of a bill and may exercise the available constitutional options. They should not use their powers to stall legislation unpalatable to them. This is so interesting and such an amazing line. You can just use this line and fetch 1 or 2 marks as it is. They should not use their powers to stall legislation unpalatable to them. अगर आपसे हजम नहीं हो रहा है, this does not mean it is not good for the state. The Council of Ministers and the Chief Ministers must have put some thought into this bill to make this a law for the people of the state. So even if it is unpalatable to you, you should not withhold it. Next, it is time to implement the principle that Panchi Commission, which reviewed the center-state relations, recommended that governors should not be burdened with the role of chancellors. So as you can imagine, the Delhi governor is the vice chancellor or the chancellor for university. So in Delhi we have the Delhi Technological University. So the governor, the lieutenant governor, is the vice chancellor for the university. So they should not be burdened with this extra role. The governors seem to have exaggerated notion of their own roles under the constitution. They're expected to defend the constitution and may use their powers to caution elected regimes against violating the constitution. But this does not mean that they can use the absence of time frame for a decision making and discretionary space given to them to function as a parallel power center. A parallel power center. This again is a very interesting and a very, very good line that can be used directly in the exam. So, parallel power centers, unpalatable laws, they should not use their powers to stall legislation, unpalatable to them. Let us look at the questions that were asked in the exam and do write in the answer in the comment section if you can. Which of the following are the discretionary powers given to the governor of a state? This was asked in prelims 2014. Sending a report to the President of India for imposing President's rule, appointing the ministers, reserving certain bills passed by state legislature for consideration of the President of India, making the rules to conduct business of the state government. This feels very wrong, right? So 1, 2, 3 seems correct to us. Let's see if they have an option of 1, 2, 3. No, they don't have an option. Whichever option has 4, we are just going to eliminate that. We just eliminated 2. We're left with 2 options now. 1 and 2, 1 and 3. 1 is the correct, right? So 2 and 3. Appointing the ministers. We just saw in the article, he just works on the advice of the chief minister to appoint ministers. Let's look at the third one as well. Reserving certain bills passed by state legislature for consideration of the President of India. We just saw this in the article as well, the newspaper article. The governor can send a bill or an ordinance to the president for his review and his remarks, passed by the state legislature for consideration of the President of India. So both of them looks right, but we are not going to go with second because we just saw that he works on the advice of the CM and Council of Ministers, and CM is the one who appoints the Council of Ministers. He just tells them ki sir, these are the people that need to be called and these are the people I'm choosing as my Council of Ministers. So the governor does not have a direct role to play in this. Hence we'll go with 1 and 3 only. Write your comments and your problems in the description as well, and we'll look into them. Whether the Supreme Court judgment can settle a political tussle between the Lieutenant Governor and elected government of Delhi? Examine. This was a 2008 mains question, and hence this topic becomes very, very hot for the preparation. Discuss the essential conditions for exercise of legislative powers by the governor. And the next question is, discuss the legality of re-promulgation of ordinances by governor without placing them before the legislature. Re-promulgation, what does it means? To rethink or to think over or to take time to think about it, right? Re-promulgation of ordinances of the governor without placing them before the legislature. So the governor sends the bill or the ordinance back to the chief minister and tells him, think again on this, make a better law for this, there can be done something better, right? Whereas they are asking, what if we put this in front of legislature and whatever they decide, the governor has to sign it, as happens in the case of the president and the central government. So yes, thank you everyone. This was it. This was the article. We hope you liked it. This was an extensive and exhaustive one because now we are moving to the region where we need to critically analyze the news and not just read them through, because as you can see, the questions have already been asked and it becomes impetus for us and important for us to know and understand these topics to answer these questions very well. Hope you liked it. If you liked it, do share and subscribe the channel and write in the comment section below what are your questions, if you have any doubts as well, any recommendations or feedback that you have for us, and we'll look into it. Thank you everyone for tuning in. All the best for exams, and do share and subscribe the channel and keep supporting us. Thank you.